Hey everyone, it's Ryan Howell, Small Business News. I got a good one for you today. For those that don't know, this is the program where I share just some of the information I share with my clients every single day. I'm a business coach out of West Michigan and around the country. And today we're going to be looking at a bill on worker protection for warehouses. Let's go check this out. Now, with that, links to everything we're going to be talking about be in the description here. And hopefully I earn your subscription today. This is from the NFIB, the National Federation of Independent Business Owners. It's a lobby/advocacy group for business owners. So, and understand there's going to be a twist to it. I thought this was an interesting read. And we're actually going to be comparing what they have in the letter along with the actual text in the bill that they're concerned about. Again, this is for the Warehouse Worker Protection Act. The NFIB, they sent this letter to the chair and the ranking member for the Committee on Education and the Workforce, Virginia Fox and Bobby Scott. Now, the reason that we're looking into this too and why this is of importance is that ever since the Supreme Court got rid of the Chevron rule, this means the regulators are no longer able to make decisions on what the law should be. Congress can no longer just send over like a vague, hey, we want you to take this under consideration. This is what it should kind of look like. And then the regulators would refine the process down. Supreme Court said that they can't do that. So we're going to start seeing more and more of these bills coming through that are meant to enact what the regulators would have been doing. And again, good, bad, or indifferent, this just is what it is, folks. I don't want to get into the argument about that. They view this as the Warehouse Worker Protection Act as a grab bag of policies that'll settle. Let's see, they've got four specifically. We got four that they're specifically, and we're going to go and take a look at that here, and then we're going to look at it in the actual bill itself. So the bill requires OSHA to promulgate a rule that would require employees to have an individual certified and first aid on site at all times. And the new rulemaking requirement also requires small businesses to refer injured employees to a physician who is board certified in occupational medicine. This requirement would be nearly impossible to implement in rural areas and lead to extensive travel for injured employees. Now, this is the actual bill. Again, links are in the description here. So we're in section 302, and they're talking about covered employees. They mean any employees that are subject to a quota. Now, with this is a standard for protecting covered employees from delays in medical treatment. Once this is passed, all covered employers will have to have a person readily available at the covered facility of the covered employer who is adequately trained to render first aid. So they want to have somebody in each facility. So if you have multiple warehouses, the way this is written, you would need to have somebody who is adequately trained in first aid at each warehouse. Okay, there's that piece. And the second one is any covered employee who is injured, they have to be able to see a physician who is board certified in occupational medicine. And one of their concerns that they have, we go back to the letter here, is that it has to do with the travel that's going to be there. In rural areas, I'm in a rural area here, it could be upwards of 2 hours of travel to be able to go see someone board certified, where you have to pay them to go and there's travel issues. And I get why they're saying this is something that we shouldn't have to mandate. Should businesses offer that? Absolutely. However, they're saying we shouldn't be mandated. Next one here is that they have as mandates a de facto ban on nearly all workplace productivity standards. The ban would do little to improve workplace health and safety. We create an absurd and unworkable mandate on small businesses. To implement this mandate, they're talking about the bill expands the scope of the National Labor Relations Act to establish new unfair labor practice for the imposition of a quota or workplace productivity standards. So let's see what they're talking about. So I went and found the quotas here. And so let's see here. So here's prohibited quotas. This is what they're complaining about. Prevent compliance with any required meal or rest period or any other break required by federal, state, or local. Also, you can't have a quota that's going to interfere, that's going to include the time for their break or lunchtime. You can't have any quota that would prevent compliance with health and safety provisions. Okay, that makes sense. I don't know if any of those exist. No quota can prevent the use by the covered employee of bathroom facilities, including reasonable travel time to and from. Now, this one here, that is where you hear the rumors about Amazon, I believe is one of them, where people were not allowed bathroom breaks. They had to work their entire shift to go through. So that's what they're talking about. And the last one they have here would be compliance with a covered employee's right to reasonable accommodations or non-discrimination as required by the law. And that one makes sense as well. You're making reasonable accommodation. Let's say somebody who's in a wheelchair, they may not be able to stack pallets at the same rate that somebody who is fully able-bodied. That's just, you got to come with a reasonable accommodation there. So after that, the rest is really straightforward stuff they've already talked about with breaks, and then you can't violate additional things that are in the law. So far they're saying you have to have somebody in first aid, Then anybody who's injured has to be seen by somebody who's board certified in occupational medicine. And then we get into the where they're talking about productivity standards. And as far as I'm concerned, I'm looking at these productivity standards. That none of that's crazy. The biggest adjust that they're going to have to make if this does go through is instead of saying hourly, you've got to do this amount over the course of your entire shift, you have to hit this number. So that's what I'm seeing in this one. I don't think it necessarily is a de facto ban on productivity standards. I think it just means we're going to have to come up with new ones if this is passed. The third one they have on here is going to be mandates burdensome record keeping requirements on employers who track employee productivity. So with this, here's the deal. So small businesses will be required to collect and maintain the data of all employees for the duration of the employee's tenure and 3 years following separation of employment. Before we get into this, before we even look at this, so the way I'm looking at this is they're saying it's burdensome for the employer to keep records of the performance, i.e. the quota that they're having these people perform. They're saying that's a burden and how well people did. If that is a condition of their employment, that should be kept. And any small business that isn't doing that, they're missing out on data. And if they're a client of mine, I say, yo, you need to track that. Not just because it's important to make sure that you are not overworking the folks, right? You're taking care of your team, but it's also going to let you where the bookends are. This is the fastest we can get somebody going versus this other side. You know what I mean? Like it's important data. Let's get back into this here. Under record keeping, every employer is going to keep contemporaneous records of the employee work speed data for such covered employee in the aggregate work speed data for similarly situated covered employee at the same place where such covered employee performs the work for a covered employer. And written description of the quota of each covered employee provided under the subsection. So what they're saying is you've got to keep here's the work speed for the individual, here's the work speed for everybody in aggregate. All right, you're going to maintain those records for the duration of employment for each employee. And then you're also going to obviously you're going to make any sort of information available to the government as they need. That's not burdensome. That's actually good data collection. So I don't agree with the NFIB on this one in any way, shape, or form. And then the last one they get here is creates a quota task force. They got the language in there. Let's go see what the text actually says. So quota task force. Not later than 90 days after the date of the enactment of this section, the director shall convene a task force with labor organizations, worker advocacy organizations, and covered employees to develop strategies for labor and worker advocacy organizations to assist in the enforcement of this section. So they're saying the government is going to put together a task force with all of these agencies to include employees will be in this. This is high level stuff here. How to assist in the enforcement of the section. Train covered employees with respect to new rights provided through this section. Provide the director with recommendations on the implementation of regulations. We're going to go through, it's going to strike some stuff here. Investigation, inserting investigation or inspection. So rather than just looking into things when something's reported, they're going to be inspecting on a consistent basis, what that means. Then this last section here, they're going to add the following. The secretary acting through this is some 1984 stuff, just the name that they put on this. Anyways, acting through the director of the Fairness and Transparency Division. Man, I'm seriously, you can see that in 1984. Sometimes I got to think about the names of these things. Shall investigate violations of Section 8, including violations here. In addition to powers otherwise provided, the secretary under this subsection, investigating violation, the secretary, upon presenting appropriate credentials to the owner, operator, or agent in charge, can enter without delay at reasonable times any covered facility. So they can do spot inspections. And really, they're just going to be going through and looking at everything that you have on there to take a look and then make recommendations back. That's what they're saying. So this is my thoughts on this here. So if we go back through here, again, I worked in government for a while and I've worked with unions quite a bit. So this is pretty standard that they have in here. I don't know what the final bit of this bill is going to look like, but I can tell you the burden for business owners to have somebody certified in first aid on site at all times, that's going to be a huge upfront cost. They're going to have to manage that in one way, shape, or form. They may not have a nurse on site. They may end up having be where shift leads or other people are going to be certified first aid. And maybe the way they do that may have multiple people where they get them first aid certified. It's just going to be a cost they're going to have. So the issue that I think is going to arise here is that either they're going to rework this or just strike it entirely. People are going to want to go to their regular doctor first and then be referred, not the businesses making a straight referral. I can see where that would just go away. The mandate on a de facto ban, I don't see that. What it is it's the productivity is just being expanded over the course of the entire day instead of being like per hour, those type of things. And then we get into the record keeping and then the task force stuff. I can see why there's concern about this. Again, let me just do a quick recap here. I've done all of these things without being mandated at pretty much every single place that I've worked at. It's just good business to do these things. We had first aid certified folks around. We made sure we just had them available. We offered it to people to have. I thought it was just good to have that knowledge around. It worked out really well too. And anytime we did unfortunately have an injury, people knew what to do. And there was definitely goodness that came with it. It was a cost, absolutely. The other spot here is that requirement when they talk about the board certified in occupational medicine. We had an occupational medicine specialist come into our organizations, look at how our people worked, and we made adjustments to off of their recommendations, as well as they gave us stretching advice and things we could do to help minimize occupational injuries for in the office, for out on the floor, out in the warehouse, in the shop, wherever it was. So this was something we did already. That being said, being mandated, I can see in rural areas, it's definitely a problem for sure. The ban workplace productivity standards, that's just hyperbole. They're not getting rid of it. They're simply just saying these are the rules that you need to work under. Okay, we'll make adjustments if it goes through. Then there's us about record keeping. Again, the record keeping is not going to be going away. Specifically, they want to make sure that it's fair and you're not creating quotas that are not realistic to terminate people. That's what they're going to be looking at when they talk about the fairness here. And you should be keeping that data anyways. It's important data. It allows you for forecasting for production and operations, how fast you can produce things, be able to ship it, whatever it is. You need that data anyways. So just keep track of it. It's not that big of a deal. It's not like we have rooms full of file cabinets anymore. It lives in the cloud. And then the quota task force, I can see that one getting thrown out in some way, shape, or form. It's the main difference there is rather than being investigatory, I think is the word, it's spot inspections. And I just don't see that as being something that is required or needed. Frankly, it's a waste of taxpayer dollars. That's something that OSHA can already have some authority to do. They don't need to have a special section just to do that. But anyways, like I said, links to all this in the description. I highly recommend always reviewing these pertinent documents whenever they come up. So with that, I hope you earned your subscription today. Take care, and I will see you next time.